Good afternoon, everyone. My name is Eugene. Oh, I'm research fellow at KICJ, and I'll be moderating the conference today. I'm very pleased to welcome all of you to the second Asia Pacific Expert Conference for Criminal Justice on the theme of promoting human rights in response to technology-assisted crimes, tackling violence against women and children. The conference is scheduled to be held for about 2 hours, and the presentations and discussion are in English and Korean, and we provide simultaneous interpretation. So if you wish to change the language, please select one of the language options on Zoom, and the forum is also live streamed on YouTube in English and Korean. Now, we are going to begin with the opening remarks by Professor Ha Tae-hoon, President of Korean Institute of Criminology and Justice. Please welcome President Ha Tae-hoon.
안녕하십니까. 한국
Good afternoon, everyone. I am Ha Tae-hoon, President of the Korean Institute of Criminology and Justice. We are holding the second Asia-Pacific Expert Conference in Criminal Justice and dealing with the topic promoting human rights in response to technology-assisted crimes, tackling violence against women and children. And we are happy to convene this conference. Due to the COVID-19 pandemic, we could not gather together face-to-face, regrettably. However, I would like to thank all participants who are joining us online to share their valuable input. Technological development makes our lives all the more convenient and comfortable. And with the development of ICT, our daily lives have expanded further to include virtual spaces. But there are also unforeseen harms. We face increased risk and anxiety as new types of crimes emerge that employ advanced technology and sophisticated criminal techniques. Digital information and communication technology are used for crime prevention and crime investigation to create a safe society. But at the same time, cybercrime based on advanced technology is also increasing. Now we have to deal with the challenge of addressing harmful repercussions while embracing the benefits of such technology. According to statistics, cybercrime using information and communication technology is on the rise. The criminal landscape is changing. Women and children are relatively more exposed to new types of technology-facilitated crime, as well as traditional forms of crime. Examples include digital sexual exploitation crimes, domestic violence via ICT, and sex crimes in the metaverse. As cybercrime is a crime without borders, transnational responses are needed. Since criminals are also proficient in ICT, responding to them also requires expertise. With us are the experts. I extend my gratitude to our distinguished speakers, Dr. Rick Brown, Deputy Director of the AIEC, Dr. Bridget Harris, Professor of Criminology at Monash University, Police Lieutenant Colonel Pipram Mekiano from the Royal Thai Police. Thank you. Dr. Taekyung Kang of KICJ, and discussants including Ms. Yoon Jung-jun, Legislative Researcher of National Assembly Research Service, Research Fellow Dahae Chung of KICJ, and Prosecutor Jin-hee Lee. Thank you. We are dealing with the topic of promoting human rights in response to technology-assisted crimes and tackling violence against women and children. I hope we will have a fruitful discussion. Thank you.
Thank you very much. Now let's move on to the presentations. We are going to hear from 4 speakers today. Dr. Rick Brown from the Australian Institute of Criminology, Dr. Bridget Harris from Monash University in Australia, Dr. Kang Tae-kyung from KICJ, and Police Lieutenant Colonel Pipram Mekiano from the Royal Thai Police. So I would like to remind our speakers that you have 15 minutes for your presentation, and we're going to have discussion after all the presentations are finished. So now I would like to invite the first speaker, Dr. Rick Brown. Is the Deputy Director of the Australian Institute of Criminology. And his research experience covers a broad range of issues related to crime prevention, community safety, and policing. And Dr. Brown is going to give a presentation today on Australian consumers of live-streamed child sexual abuse in the Philippines. Dr. Brown, please.
Thank you so much. Let me start by sharing my screen. And can I start by thanking you for this invitation to speak at this conference, and as a fellow UN P&I member, we're delighted and privileged to be able to present here today. For this presentation, I'd like to acknowledge my colleagues who have been involved with this program of work on live streaming of child sexual abuse, including Sarah Napier, Hayley Boxall, Tim Cubitt, and Cohen Tunison, who together have delivered this program of work over the last 2 or 3 years. To start with, I'll introduce you to Sweetie, who in 2013 Terre des Hommes ran as an experiment to explore the extent of live streaming demand. Sweetie was a computer-generated avatar representing a 10-year-old Filipino girl, and over the course of 10 weeks, researchers used Sweetie in 19 chat rooms to basically explore interactions with people engaging with her. She was engaging in a non-sexually explicit way, and over those 10 weeks, 20,000 offenders from 71 countries solicited live-streamed sexual performances from her. So it just underlines the scale of the global demand. And we know that in recent years during COVID, there's also been an increase in demand for live-streamed child sexual abuse as well. So this analysis is based on financial transactions that were collected by AUSTRAC, a government agency who's responsible for preventing and detecting criminal abuse of the financial system. Next slide, please. Can I just check whether the slide has changed?
Yes.
It's not changing from my side. So. Okay.
Please go on.
Right, I can see it now. Okay, so the slide here just shows the presentation so it shows the design for the research project. So this was based on a police operation undertaken by Philippines National Police that identified 118 facilitators of live-streamed CSA in the Philippines, and those 118 facilitators had 256 individuals in the UK sending money to them for live-streamed services. We identified the financial transactions associated with those 256 individuals. And then thirdly, we combined criminal histories of those 256 individuals that were provided by the Australian Criminal Intelligence Commission. So it's very much a partnership approach that takes on board all of those agencies. Next slide, please. So next, we are able to glean some demographics based on those financial transactions. Next slide, please. In terms of the average age of those involved, the perpetrators on average will range from 20 to 76 years. On average were 54 years of age. Interestingly, 67% of transactions were in the age range of 50 to 69-year-olds. And if we shorten that a bit and look at the 50 to 59-year-olds, 41% fell within just that 10-year period. And that compares to 12% of the Australian population that are aged 50 to 59. So it really was kind of that age group were overrepresented. When we look at the age of onset, so the youngest age for each of these individuals when they made a transaction to these facilitators, it was 52. So that's in terms of criminality, this is unusual for to have a sample of offenders aged onset into offending so late in their lives. When we looked at occupation, there was some occupational information available in the AUSTRAC records, showed a real mix of different sorts of occupations that were listed for the perpetrators, the Australian offenders, ranging from aged care workers, boilermakers, carpenters, chefs, general managers, architects, and accountants, to name just a few. Next slide, please. As we said, we were able to get hold of the offence histories for the 256 individuals. And interestingly, what we found was that about half had no official criminal history at all yet. Bear in mind, every one of these were committing child sex offences against children in the Philippines via live streaming. 7% had a sexual offence against a child. About another 6% had committed a sexual offence against an adult. So about overall, there was some overlap there. So about 10% had some sort of sexual offence history. Next slide, please. So next, I'm just going to focus on the financial transactions that those individuals made. In fact, there were 2,714 financial transactions made to those facilitators for live stream child sex abuse. Now here we've got a chart that shows along the bottom percentage of live stream purchasers and on the left percentage of transactions. And if transactions were equally distributed, you'd see a straight line diagonally from bottom left to top right. But in fact, we've got an incredibly concentrated set of transactions here. So just 5% of purchasers made 60% of the transactions, which we see on the left-hand side. And on the right-hand side, we can see that 25% of the live stream purchasers accounted for just 3% of the purchases. In fact, almost half, 48%, made just one transaction. And we're not sure why that's the case, whether in fact some of those transactions were in fact scams and they didn't actually receive anything, whether they were just testing to see what was there, or whether they moved on to other facilitators after paying these particular facilitators. Next slide, please. Next, I just want to show you that over time, the more transactions that were made, the more offending escalated. So if I just go to the next slide, we can see the average number of days between live stream transactions. So along the bottom here, we've got the transaction number, so transaction from transaction 1 to 2, 3 to 4, etc. And then we've got the number of days on the left-hand side. What this shows is the second transaction, so between the first transaction and the second transaction, on average, 63 days elapsed between live stream transactions. Then if we go to the right-hand end, we can see that over time, the more transactions that were made, the time elapsed between transactions got shorter. So the final transaction between 49 and 50 was in fact just 12 days. Okay, next slide, please. When we look at the average value of the transactions that were made, we can see actually the opposite, that as we move from one transaction to the next, the amount that individuals were willing to pay on average increased. So from transaction 1 to 2, the second transaction on average cost $53, and by the time the 50th transaction was made, the offenders were willing to pay $162. We think this may be a proxy for severity of offending. Basically, they're paying more for more severe child sexual abuse in those live stream sessions. and which is, as we know from the literature, that individuals get desensitized and ask for more serious behaviors over time. Next slide, please. When we put those two together, we can see that there is a relationship between the two. As offenders watch more live stream child sex abuse, the quicker they want to see more, and the more they're willing to pay for it. So as one goes up, the other goes down. Okay, next slide, please. Now, using the same data, we've undertaken some machine learning analysis using k-means to try and segment our population. And when we ask, are all live streaming offenders the same? The answer is clearly no. So next slide, please. We can particularly identify two distinct groups that exist in our data here, and there are some interesting differences between them. Next slide, please. So we just look at some of the differences here between the two clusters we found. We find that the cluster 2 is seemingly a more serious group in many ways than cluster 1, although a smaller group with just 28 offenders compared to 178 in our first cluster. So we find that the age of onset is, the age of onset is slightly later, so it's 54 compared to 52. The mean number of convictions, though, is much higher at 12 as opposed to 2. The mean number of live streaming transactions, though, is lower, so they're not as prolific as other live streaming offenders. Although the time that elapses between transactions is shorter, and they tend to pay a little less than the first cluster, which is interesting too, which we think may be about them being more likely to negotiate in making transactions. Which brings us on to our next slide, please, which is another set of analyses around chat logs for live streamed offenders. This analysis is based on 7 individuals whose chat logs we were able to obtain for offending between 2012 and 2019. Next slide, please. These 7 offenders were participating through chat logs on Facebook, Skype, Yahoo Messenger, and on Viber. And Yahoo Messenger no longer exists, and it's kind of an indication of some of the older chat logs we had access to. Next slide, please. When we look at who initiated the contact in the negotiations, we find quite a complex picture. We find about 2/3 involve the offenders making the first move with facilitators. But we find in 14% of cases, it's actually the facilitator that makes the first move. And in a small number of cases, we found it was the victim actually approaching the offender, which kind of identifies and highlights some of the complexities here in the nature of the offending that we're examining. Here also we have on the right-hand side just 2 examples of the offender chats that occurred. In the top right case, that's one where there was the offender led the discussion, and then in the bottom right one where the facilitator led the discussion. And I'll just note that there's very little small talk and very quickly gets into negotiations between offender and the facilitator. Next slide, please. And here we have 2 examples that just show how the offender tries to reduce the amount that they pay for the live streaming, while the facilitator is looking to increase and maximize the amount that's charged. In that second example at the bottom there, I'll just point out that the offender eventually paid 1,200 Filipino pesos, which is equivalent to about 30 Australian dollars or 28,000 Korean won. Next slide, please. And here's just a final example that shows some of the bargaining and negotiation that goes on. In this example, the offender is very clear about how much they want to pay, but negotiates a lower price, but for one show now and for another one into the future. So they're basically paying for abuse of two sessions of abuse at the same time. Okay, next slide, please. Okay, that's just a summary of the different analyses we're undertaking at the moment, and it's part of a continued program of research around live stream child sex abuse. Thank you.
Thank you very much. Now we are going to have Dr. Bridget Harris, who is an Australian Research Council Discovery Early Career Research Award Fellow, and she's also Deputy Director of the Monash Gender and Family Violence Prevention Center and Associate Professor of Criminology at Monash University. And her research expertise focuses upon domestic and family violence, violence against women, and technology-facilitated harm. And today, Dr. Harris is going to talk about digital coercive control in the context of technology-facilitated domestic violence. Dr. Harris?
Thank you. Thank you so much for the invitation to speak today, for organising this event. I want to just begin by acknowledging that I am speaking on unceded Wiradjuri lands in Melbourne, and to pay my respects to elders past and present. So technology has long been used by perpetrators. We could think about in past decades how perpetrators might restrict access to landline phones or to cars. We can think about these as forms of technology. But in recent years, we have seen some shifts, and that's because of new forms of technologies that have evolved. It's also because of the roles technologies now play in our lives and increases in uptake of technology throughout communities. This has created some new forms of abuse and new channels for abuse. Technology is simply another tool that perpetrators use, but it does have some unique features and also impacts. Firstly, that is because it is spaceless. So it is not confined to any geographic location. So somebody could be exposed to harm anywhere they access digital media or a device. It also allows for constant contact and constant accessibility if we think about how our communication technologies work, and constant visibility if we think about how our surveillance technologies work. This means it really complicates how somebody experiences violence, how survivors can protect themselves from violence, and how they can exit violent relationships. And it can be a big deterrent to exiting violent relationships. There are extensive impacts on somebody's well-being, security, and sense of safety. Now, there are positive elements to technologies. There are ways we can harness technology, and we see survivors accessing information and support through technology. We see advocates and practitioners using technologies. So I don't have time to talk about that further now, but I think it's really important to recognise that just as technologies are weaponised, they can also be harnessed for good and preventing and responding to violence. We often talk about different forms of abuse, for instance, financial, sexual, physical, psychological, and emotional abuse. But I think it's really important to recognise, as you can see here in a power and control wheel that was developed by some really fantastic advocates in Australia, WESNet, that technology is used to enact so many different forms of harm and abuse. So it's really hard to separate out these categories. Technology can, for instance, be used to engage in economic abuse. So somebody's banking accounts might be controlled or accessed through a banking app or an online account. So what behaviours are we talking about here? I think it is really useful to try and develop a definition to try and categorise these harms, and that's for a few different reasons. Firstly, it can help in identification of harm. So it can help survivors, for instance, recognise what abusive behaviour might look like. It's also really important for advocates and practitioners in trying to prevent harm and respond to harm to be able to identify specific behaviours and strategies to address these harms. But it's really challenging. And that's firstly because technologies evolve. We see new technologies arise and the existing functions of technologies change. There might be differences in how apps work every time there's an update, for instance. And also, perpetrator behaviours change. So because of all of these elements constantly evolving, if we are using a fixed definition, I think it's really important that we're reflecting on this definition and constantly updating what we're talking about. But here you can see some of the common behaviours that both victim survivors, advocates and practitioners will talk about. So as I mentioned, in regards to, for instance, economic abuse, we see technology used to engage in other forms of abuse, and also traditional stalking, so that in-person stalking. So somebody, for instance, might use an app or a GPS tracker to find out where a survivor is and turn up to that location in person. But technology can also be used to monitor activities, movements, or communications. It's fairly common that perpetrators will send or post abusive acts or communications using technology. And that might be, for instance, sending verbally abusive messages, so emotional abuse through technology, through, say, social media. And we also see this occurring often at quite high volume. So it might be a large number of phone calls or messages that are sent. Perpetrators might cause an unauthorised function on a device, and this could be, for instance, in a smart home. It might be changing the setting of temperature, it might be turning lights on and off, it might be changing music, and these could be more subtle or they could be more obvious kind of changes of functions of technology. Perpetrators might also impair an authorised function of technology. So they might do things like restrict the ability for survivors to send messages from phones or computers or tablets, or to make calls. We see perpetrators accessing devices or digital accounts without permissions, or destroying technologies, or denying access to technology. So this might be destroying or denying access to a phone. It might be destroying or denying access to assistive technologies. And those might be technologies that survivors with disabilities use, for instance, hearing aids. We see perpetrators engaging in image-based sexual abuse. So that is the non-consensual creation and or distribution of intimate images. We see doxing, that's the publishing of private and identifying information without consent. It might be, for instance, posting a survivor's image and the address that they work at, or the address they live at, on a public page, on a social media page. And we might see impersonation, and this could be of a victim survivor or another person. We've seen that happen with, for instance, perpetrators impersonating police officers, or children, or friends of children. And again, for a number of different purposes. It might be to intimidate, to harass, to defraud, or to steal a victim survivor's identity. So there are a number of commonly referred to behaviours that we might see, but it doesn't represent the reality and the entirety of what victim survivors experience. And that's because there are so many different techniques and strategies and channels that perpetrators will use. And again, technology is just one of these. Also, it doesn't capture all those behaviours because they're really individualised approaches. So perpetrators will use behaviours that are designed to really impact a particular person, and that might be missed in a just more general list of behaviours. So it's really important to recognise our justice system often focuses on incidences, but domestic and family violence is really comprised of patterns of behaviour. It's comprised by frequent and routine and everyday, and again, really personalised strategies of perpetrators. So some colleagues and I have suggested that instead we might refer to this as either technology facilitated coercive control or digital coercive control. And that means that we're really firstly focusing on the method. So we're thinking about digital. And then we are thinking about the intent of the perpetrator, the coercive behaviour. And finally, we're thinking about the impact on a victim survivor. So we're thinking about control and entrapment. So really how somebody's freedom is restricted. And that means that we can capture the sort of behaviours that are on those lists, the list I showed you before, the behaviours that might be really recognised in the community or problematised in the community. They might be identified in different laws, as well as those behaviours that might not be seen as serious, but are really harmful to victim survivors. So this means that what we're doing is we're recognising the context in which this is happening. We're recognising the history between the parties. We're recognising the uneven power distribution. We're recognising the setting that it is happening in. And that means we're also able to see behaviours that might also occur outside of abusive relationships. They might be seen as really helpful or positive or normal behaviours. So it's not uncommon, for instance, for people to share their location with their partner through technology, and that might be something that both parties feel makes them safer. They might feel really comfortable. They might feel just more at ease to know where the other person is. But that same technology in an abusive relationship can be really problematic. We're not talking about the same kind of consent because of, again, the history and dynamics of their relationship. And there's a huge risk for perpetrators to know where victim survivors are all the time, to be monitoring, and it really does restrict their freedoms. So in that example, we're not talking about different technologies. It's not the technology or the behaviour itself that's problematic. What is problematic is the intent and also the impact. We can think too about things like FaceTime and Zoom that we're using now, a really great way for people to connect through the pandemic, for instance. But we've seen those technologies weaponised by perpetrators, for instance, when they've asked children who are at a new house with a victim survivor to, you know, show me around your house and show me the windows and show me the doors. And it's been about trying to get intel into the security of that house. So the same behaviour, the same technologies, the same behaviour, but very different intent and impact. So it's really not just the technology that's the problem here. Perpetrators will often frame behaviours as justified because they're caring, for instance, but we really need to think about that intent of control. We also need to really challenge a traditional cybersecurity model here, and that assumes that our attacker is an unknown person and they can be prevented through things like third-party authentication, through passwords, through passcodes, because they don't have access to our devices. But that doesn't apply in this setting. And that's because we have this sharing of intimate knowledge. You might know your partner's password, or you might be able to guess their password, or you might be able to gain access to a new password because you can access the security questions, you know enough about them. There's a good chance that accounts are linked or shared, or devices are shared. Abusers can manipulate or force or coerce to get access to devices. So it's a very different threat, and it's very different dynamics between the parties. It's really important to recognise too that separation isn't when violence just stops. It escalates for many people. It's a very risky period. And even if victim survivors and perpetrators are not together, there is still this vulnerability around technology because of the intimate knowledge, because of the previously or still shared accounts and devices. So instead, I think it's really useful when we're trying to think about risk and safety to firstly ask survivors what behaviours make you feel uneasy and uncomfortable, and we're not just confined to, for instance, the behaviours that I showed you before or what is identified in law. And that's because it really will provide us with more insight into the experience of violence, the potential risk, and to really see coercive control in that context. It's important to think about, again, separation as being a time of risk, and children are very much involved in that process. Children are often victims themselves, and we need to be thinking about, okay, well, what technologies are children using? What technologies are moving between the two houses if victim survivors are separated but sharing parenting? And it's important to think about what technologies are being used by a survivor, by a perpetrator, and are in the house, because we need to be thinking about all of these different points as access points. Digital coercive control, I would argue, is really key in providing intel for risk assessment and safety planning. And that's because it can show what I refer to as homicide flags, some of the risk factors associated with fatal violence. One of those is obsessive behaviours. We can often see that through the high volume of contacts that perpetrators have, many phone calls or messages that they might make. Stalking is another homicide flag, and we can often see perpetrators monitoring and stalking through technology. And coercive control is another homicide flag. And we can see that, again, if we're looking more comprehensively at what coercive control looks like by asking questions like what makes you uneasy and uncomfortable, and thinking about intent and impact. There's often a lot of pressure on victim survivors just to stop using technology or change their behaviour. Really difficult if you think about the role technology has in our lives for education, employment, socialising, managing households. But it's also not necessarily the answer or something that will make a person safer. And that's because if a perpetrator is engaging in obsessive or coercive and controlling behaviours, shutting down one channel doesn't mean the behaviour will necessarily stop. What we might see is, for instance, an increase in physical violence or in-person stalking. So really important that we give space and assist survivors if they want to stop using technology, but we don't automatically suggest disengaging or see that as something safer. And more than happy to share any resources or to be contacted to chat about this further. Thank you.
Thank you for your insightful presentation, Dr. Harris. Our next speaker is Dr. Kang Tae-kyung. He's research fellow at KICJ and has been working on the issues of human rights in criminal justice and jurisprudential grounds for criminal justice policies. And the topic of his presentation today is new types of harmful acts that appear on metaverse and how we can understand and regulate them in criminal justice.
안녕하세요.
Hello, everyone. I would like to thank the KICJ for inviting me. It's nice to meet Dr. Brown again. I'd like to talk about criminal implications of metaverse-based harmful acts. I would like to pose these two questions and provide you with the answers. One, what is a metaverse-based harmful act? In order to answer this question, I would like to discuss the characteristics of the metaverse as a means and metaverse as a space. And from these two characteristics of the metaverse, we can identify two types of harmful acts. And then I'd like to talk about who are vulnerable to such metaverse-based harmful acts. And the second question I'd like to pose is, how should we regulate MHAs? We have to be faithful to the Nulla Pena Sine Lege, or no punishment without law. And we also should be prudent about criminalizing MHAs because we have to consider the developments in metaverse. We can divide the development stages of metaverse into 4 depending on the level of immersion. Stage 1, headsets and hand controllers are used, and we have sight, hearing, and a limited form of touch. In stage 2, bodysuits and omnidimensional shoes are used. Haptic VR tech is used so that you can feel full body movements and you can have full sense of touch. And experts say that the immersion level is 80%. In the near future, we believe we will reach stage 2 of metaverse technology. Moving on, stage 3 enables neurorehabilitation. It requires neurohaptic VR. It will send signals directly to the brain to fully replicate a virtual environment, and this will reach 100% immersion. And a more advanced level, stage 4, is it will allow mapping the mind and uploading one's brain to the metaverse. And the two worlds will be indistinguishable. It will be very difficult for the user to identify between the two worlds. With these in mind, I'd like to now focus on metaverse as a means and as a space. If you consider metaverse as a means of communication, it can be a means for information exchange, and the metaverse-based activities facilitate communicating and forming relationships in the real world. For example, the former Facebook, the Meta company is developing the metaverse platform as a fourth generation SNS. And considering metaverse as a space in virtual reality, it's a space where we simulate real-world communication and real relationships. And the metaverse is a distinct space separate from the real world. And a good example would be the BTS holding their concert on the metaverse platform. Then who are the main users of metaverse? As you probably expected, the main users include children and adolescents. We have about 300 million global subscribers to Zepeto, and monthly active users number 20 million, and 71% of them are aged 7 to 18 years old, and Roblox has 150 million monthly active users, and users aged 7 to 18 account for 62%. And according to KOKA, Korea Content Agency, the younger the users are, the earlier they start their metaverse experience and the longer they stay in metaverse. So in this world, mainly used by the youth and children, we've had recently online grooming incident. It was a male user in his 30s decorated his avatar magnificently, provided children with gifts, gifticons, and did online child grooming and sexual exploitation. And we see frequent cases of cyber fraud in metaverse. It usually happens in a metaverse account and item transactions. And mostly there are teen victims, and users under the age of 14 are vulnerable to such scams because they want to purchase these items. And according to NIA, a Korean information agency, teens' experiences of cyber, verbal violence, defamation, stalking, privacy-related damage, bullying, extortion, and coercion are increasing, but only 4.9% of the cases are reported. And violence against an avatar is rarely considered a crime, but teens have this great sense of emotional unity and connection with avatars, so harassment between avatars can also be felt as physical pain.
메타버스 기반 가해행위의 두 가지.
Let's take a look at the two types of harm. First is including this for real world crimes. This type of crimes can be constituted as crimes under existing law. For example, if we take a look at metaverse item fraud, the court considered online game items as property interest and applied fraud to the act of online game item scams. The metaverse item can also be treated as property interest as well. Next, we can think of online sexual exploitation and grooming. This could be in violation of Article 15-2 of the Act on the Protection of Children and Youth Against Sex Offenses, and exploitation can be violation of Article 11 of the same Act. Article 11 of the Act gives police authority to conduct disguised investigations into digital sex offenses against children and youth. And so the previous cases have been investigated through disguised investigations based on these laws. But however, not all acts of this type can constitute crimes under existing law. In the case of online impersonation in California, New York, and Texas, they criminalize online impersonation itself, which is committed for the purpose of harming, threatening, intimidating, and defrauding others. However, this is not punished unless it causes damage in Korea. A revision to the Act on the Promotion of Information and Communication Network Use and Information Protection is under review. Let's take a look at the second type of harmful acts. This is when metaverse is a space for harmful acts. Verbal violence against avatars can be violation of Article 311 of the Criminal Act, stalking, assault, and sexual violence against actions against avatars, can these actions be treated as real-world assaults and sexual violence? What we need to consider at this point in time is whether the core of such activity is an expression or a behavior. If it is an expression, then it would be insult, defamation, or harassment. But if this is a behavior, then assault can be applied. That is the conceptual idea that we can have. However, based on the principle of legality, we prohibit analogical applications. And so in order to punish this type of actions, we must have new legislation. Who are the victims and the offenders? This is something that we need to review in order to criminalize such actions. Within the metaverse, are avatars considered independent legal personalities? That actually can be done according to the current law. However, if we take a look at the victims are the subject who suffers damage, and the offenders are the subject to whom the responsibility is assigned. And so, the avatars, are they just proxies for persons? Well, we can't say that avatars are real persons. If we say that avatars are real persons, then we have a totally new definition of the victims and offenders in the metaverse. And we believe that this is something that we should be considering after stage 3 or beyond in the course of metaverse development. What we also need to consider for criminalization is the definition of the damage itself. Can the damage resulting from metaverse-based action be recognized as identical to the resulting of real-world crimes? I think we can think of this in different stages of metaverse development. Currently, we are in stage 1 and soon to be stage 2. We believe that the user's immersion is not enough to view the two kinds of damage as the same. However, in stage 3 and beyond, the immersion can be enough to view the two sorts of crimes as being the same. The possibility also depends on the user's sense of unity with metaverse and the real world. As we have seen in previous surveys, the younger the users, the severer their damage can be within the metaverse. And so, therefore, this is in relation to the theme that we have today, which is protection for women and children. The last issue that we must review is whether these acts can be morally blamed. Since such actions harm others' social reputation, sexual freedom, or property interests, they are definitely blameworthy morally. And so, we need to have normative regulation of such actions. Having said that, how should we have the legal regulations for actions in the metaverse? Of course, there is a gap in the punishment. For example, rape or compulsive indecent acts against avatars or avatars' public indecency and stalking avatars are not punished as crimes under the current Korean law. But in order to regulate such acts, should we have an independent law that is newly legislated? Concerning this need, I would like to say that I think we need to wait and see, because the law is unsuited for immediate responses to rapid technological developments. And it is premature to enact laws governing metaverse-based actions separately. It is time to consider flexible legislation to cope with various types of new crimes currently occurring and evolving in the future. Considering the current stage of metaverse development, it is more reasonable to regulate such acts such as rape against avatars with the Information and Communication Network Act rather than Sexual Violence Punishment Act. Is it best to criminalize such actions, even if it is under the Act for Information and Communication Network? We need to consider the obligation of the state to support and develop science and technology. And so we need more proactive prevention than ex post regulation. The law should put metaverse developers under obligation to control interactions that can cause mental and physical harm to users in that metaverse. The law should also put metaverse developers under obligations to provide users with an opportunity to train their competency to protect themselves in the metaverse. These are some choices that I would like to propose. This brings me to the end of my presentation. Thank you very much.
For your presentation. Finally, Police Lieutenant Colonel Piapro Mekianon is serving as Deputy Superintendent of Cyber Crimes Against Children at the Cybercrime Investigation Bureau of the Royal Thai Police. Lieutenant Colonel Piaprom has extensive experience in legal practices, including child online exploitation investigations. And she's going to give a presentation today on the issue of self-generated child sexual abuse material, which is a growing problem in Thailand. Lieutenant Colonel Piapom?
Yes.
Please.
Can you hear me, Kerry?
Yes.
Okay. First of all, I would like to thank for having me here today. So, without undue delay, I would like to start by giving you an overview the statistic of the internet user in Thailand from 2013 to 2021. For the past few years, we are now entering the Thailand 4.0, which aims to drive the economic through innovation, bringing modern technology to help the country development. Also, the price of the smartphone in the market goes cheaper, allow more people access to internet. This result in online activity and services that are rapidly increased and exacerbated by COVID-19 pandemic cause a profound impact on the society and people to adjust their behavior and lifestyle by working and studying at home. And today, people are diverse and can be classified into what is called generation: baby boomer, Gen X, Gen Y, Gen Z, and Gen Alpha. My presentation is intended to talk about Generation Alpha, which refer to children who is their birth year range is from 2010 to 2025. The audience member is now should be 12 years old. Generation Alpha is the generation after Generation Z. So the Generation Z has strong impact on them, and that's the reason why I'm going to mention a lot about Gen Z who are under 18 years old. They're growing up in a digital environment, or we commonly call them digital natives. In the past, the difference between people in each generation may not be much, but the impact of digital technology makes Gen Z and Gen Alpha have quite different behavior, thought, and belief from the previous generation. The most popular activities among young children during pandemic. When school closed, social distancing imposed, many children are spending more of their time at home, study, playing games, and communicate with friends. Much of their time spent online and often for longer period than usual. Spending more time online increase the likelihood that children come into contact with online predator, and let's talk about the dark side of the digital age and cybercrime, which are becoming more and more common because it can arise from anywhere without border to anyone at any time. Technology has a negative impact on people of our age. But for young children, they become more vulnerable because they lack the knowledge and skill to protect themselves from online predators. From the National Center for Missing and Exploited Children, or NECMEC, public cyber tip line report of child sexual abuse materials last year. Since the start of pandemic, online child sexual abuse material, or CSAM, involved Thai children have increased dramatically. And as you can see from the PowerPoint, even though during the COVID pandemic, the sex tourists, especially the white male from Europe and America, has decreased, but children are still vulnerable to sexual exploitation because many pedophiles are still living in Thailand and they get married with Thai women, and many of them often goes online, resorts to the increasing demand for CSAM and leading to more commercial sexual exploitation of children through the internet by using social media platform, for example, VK, Live, or even in the dark web. Here is the interesting finding from the recent research from Disrupting Harm in Thailand. Students say that experience of sexual exploitation or abuse involves social media from the four biggest platforms, namely Facebook, Twitter, Instagram, and TikTok. Advances in technology have dramatically changed the way people communicate, behave, and perception toward what we interact with each other. These include the perception of normalcy to share nude photos of themselves with their friends. It's become normal for young minors to share nudes with each other. They don't aware the danger of sharing their indecent photo to someone they know online. Social media has very strong impact on young children, especially Gen Z and Alpha, since there are a lot of platforms offer young people the opportunity to share sexually explicit photos of themselves online. In many cases, they have shared it with someone they didn't know offline, just want to gain number of likes, followers, or a gift. Also, there's a lot of cases that predators groom children for sexual exploitation, especially for younger children who are less than 9 years old in my country. And there are a lot of CSAM came from parent or caretaker. Nowadays, parents use social media to show the baby photo, including activity in their daily life. Some parents not only post photo of their children on their social account, but they are also creating a page or having an Instagram, especially for their kids. Some indecent photo of their kids have been shared without intention. For example, the picture while the kid taking a bath, or disseminate private information by not knowing the danger and how to share their baby photo and information appropriately. As I mentioned, young children don't aware of the negative consequence of sharing self-generated sexual image or video of themselves. They did not expect the outcome that lead to blackmail or extortion and resort to suicide among adolescents. From this statistic, the number of adolescents who show the sign of depression has increased 4% and tend to increase every year. And this creates a dilemma faced to law enforcement on how to respond to the production and distribution of self-produced child pornography. My question is, should children be prosecuted for sharing self-generated sexual image or video of themselves? My answer is, we never place charge on children. We place charge on adults who force, threaten, indulge instigate or encourage a child to do so. In Thailand, the main legislation addressing offenses related to child sexual exploitation is the Thai Penal Code law, provide a quite comprehensive definition of such child sexual exploitation and criminalize certain acts associated with CSAM. And the Computer Crime Act criminalize the possession, sharing, and download of any child pornography to the computer. The Child Protection Act criminalize the act of forcing, threatening, inducing, instigating, encouraging, or allowing a child to perform or act in pornographic manner. And the Anti-Trafficking in Person Act gives the definition of exploitation related to seeking benefit from the production or distribution of child pornographic material. And when it comes to international cooperation, we have provision on extraterritorial jurisdiction included in the Thai Penal Code law. And we also have a channel of communication. We have done to mutual legal assistance or MLAT. So all police requests shall be submitted direct to Attorney General. In the case where the requesting state does not have MLAT with Thailand, the request shall be made through diplomatic channel by Ministry of Foreign Affairs. Okay, here let's go to the real case. Using VK platform, the girl victim at that time, she was 11 years old. It started with a friend request from a young man with a handsome model-like feature who quickly gained her trust. A few days later, they began FaceTiming, and that is when their romantic relationship began. She was groomed to take sexually explicit image and video and engage in a sexual conversation. Actually, this guy recorded her photo and video and sold to a big child pornography network at VK platform. The suspect is the one who owned the private group, which contained a lot of CSAM. For anyone who wants to become a member to his group, have to pay the fee ranging from 300 to 500 baht, or let's say $6 to $50 per month for subscription. So he had more than 200,000 followers. So his financial transaction, we found that at least he had 20 fake bank account or MOO account. I think everyone here know what is a MOO account. What I highlight in the red color circle here, all of them are money MOO who transfer or move illegal money on behalf of the suspect to help launder money derived from online crime, which make it harder for law enforcement to accurately trace the money sources. For your information, in Thailand, we have more than 1 million MOO accounts available for illegal purchasing in the dark web. So let's get back to the case. Then we check a security camera at the ATM and see who withdraw the cash. And we send a suspect a fake link contain a kind of malware. So when he click on the link, his IP address and location will immediately send back to us. So we finally arrest the suspect. So what the challenge we face in this case is we cannot rely on digital evidence because we have to conduct investigation online and offline, or we have to conduct traditional criminal investigation since we cannot get basic subscriber from VK and it's not possible to get from VK. Currently, we are now working on more than 2,000 CSAM, which involve more than 100 suspects. But in my unit, we have only 20 police officers who have specialized skill in this field. Okay, as I mentioned from the previous slide, we have a lot of challenge. Meanwhile, there are a lot of incident report. So how can we use the technology to enhance our capacity to deal with the case and offer the holistic approach to help victims of crime from the beginning to the end in the justice process? So I come up with the idea on artificial intelligence or AI that can be utilized to assist and empower the victim Then I landed two projects. First project called My Seat Chatbot with the support from Thailand Institute of Justice, and the second project called Cyber Bot to help victims to easily access to justice. My Seat Chatbot focus on a gender-based violence case committed online and offline. It is a chatbot that can provide 24/7 information services for women and children accessible through Facebook Messenger. And message chatbot will immediately respond with information about how to report to the police, how to preserve evidence, and what support services and the compensation they are entitled by law. Meanwhile, cyberbot focus on any type of cybercrime, become a hub of knowledge and education on a digital literacy for children. So let's say that these two chatbots provide access to emergency support, legal action-based knowledge, as well as linked to various services. And the victim can also submit report online. This is my chatbot look like. We receive a lot of attention from in and outside country. For example, we got invitation to join in the conference on how to use chatbot to tackle gender-based violence across the world. This conference organized by Thailand Institute of Justice and World Bank. Another innovative idea I did, I also provide training to police with an aim to turn cybercrime hotline to child helpline in order to provide immediate crisis support, help to refer emergency case involve children who had a sign of depression to multidisciplinary team. So the child helpline can provide a basic counseling for children and respond to a broader range of child protection in a sensitive manner. Okay, this is at the end of my presentation. Thank you so much.
Thank you very much. Now we are going to move on to discussion. We have three discussants today. Dr. Jeon Yoon-jung, legislative researcher at the Korean National Assembly Research Service, and Dr. Jang Da-hae, research fellow at KICJ, and prosecutor Lee Jin-hee from the Korean Ministry of Justice. The discussion session goes in a way that we are going to hear from the first discussant and the presenters and answer the questions, and then move on to the next discussant. So each discussant has 5 minutes. 전윤정 박사님 먼저 시작하겠습니다.
Dr. Yoon Jung-jeon, please go ahead. Hello, everyone. I am Yoon Jung-jeon. I'm a legislative researcher at National Assembly Research Service. I'd like to thank you for inviting me as a discussant. I would like to ask questions to Dr. Brown and Professor Harris. First of all, along with rapid developments in technologies and in changes in the criminologic environments, digital sex crimes against women and children are increasing and diversifying. Advanced technologies are utilized in new ways that exploit and abuse victims. Today's conference offers a meaningful space to understand and analyze perpetrators and patterns of child sexual abuse, domestic violence mediated by technologies, intimate partner violence, violence against children and youth. To start the discussion, I would like to ask questions on Dr. Brown's presentation. The analysis of trends in digital sexual abuse through live streaming services, which has become increasingly popular, was very intriguing and thought-provoking. As for the users of the streaming platforms, how did you access them, and how could you categorize and define the live streaming users? You talked about the 4 streaming platforms. And did these users just come into the streaming platform naturally, or did you set some boundaries or categories and try to research them targeting a certain group of users? And it was also appalling to see the contact initiation ratio, because offenders 66%, facilitators 14%, victims 8%, they initiated. And you can see that the offenders used the technology to search for prey intentionally. And so, as for the use of technology and making initial contact with the victims, is there some type of regulation to protect the victims from the contact? Because in Korea, we have this system that can identify certain services as harmful media materials to youth and can shut them down. Of course, new technologies and new apps come on board, and we have a reporting system which is employed to deal with the new applications. And so there's a warning message, and then there's a button that you can press. You can report online, and then investigation takes place on that site or app. And I was wondering what kind of system you have in Australia. And I was also interested to see the page 13 of your slide. There was a correlation analysis between mean days between transactions and value of transaction. And I would like you to elaborate. So the more severe the damage, the interval was becoming shorter and the value of the transaction was increasing. And I was wondering if you could flesh out a bit on this correlation. So the average value of the transaction and the interval, they had a negative correlation. And could you expand on that? So the more frequent the transaction is, the value of the transaction is becoming lower, it seems, because there's more frequent negotiation going on. And you showed us screenshots of the negotiations taking place. And so what implications can we draw from such negotiations? And how can we act on that? I would appreciate it if you could explain that. And as for the two groups among the live streaming offenders, what I was interested in was the age profile. In Australia, the average age was between 50 to 69, and I was wondering about the characteristics of the people who belong to this age group. Because in Korea, when we look at the online chat room users or the perpetrators, they're mostly younger. They range from the youth, they're in their teens and 20s. And so could you explain about that age profile of the live streaming offenders? And lastly, is there any gender statistics of the whole user group? If not, do you plan to perform any gender statistics? Thank you very much.
Next, I would like to address digital coercive control presented by Dr. Harris. Well, if we take a look at various patterns of domestic and family violence mediated by digital technologies, I think there was a great analysis. And in particular, the need for new legislation is universal across the world. This is the same for Korea as well. Technology-mediated domestic and family violence is now starting to be dealt with in Korea, and we are reviewing additional legislation. And so having said that, in Australia, are you reviewing any detailed and specific laws to be enacted in order to define such crimes or to punish such crimes? Is there any institutionalization or legislation movements? The next question is, as you have mentioned in your presentation, Dr. Harris, using technology, it could be used to prevent harm and also to prove harm, but at the same time, it could be used by the perpetrators themselves, as you have mentioned. And this is something that we are also focusing on in Korea as well. So when perpetrators are using technologies for violence against victims, how are we going to regulate this? And how are we going to conceptualize such regulations? You talked about focusing on patterns as well as strategies and intent, but could you share with us any specific ways of institutionalizing such categorization and intent? And I also have a few questions for both Dr. Brown and Dr. Harris. When we think about technology-mediated violence, then we usually picture specific platforms or websites. And that would mean that it would not be within one country, but it could be cross-border. So if there is a platform that is being operated by a foreign company, then it is very difficult to regulate this with just domestic laws. In such cases, what would be ways to regulate this domestically? And are there any discussions in Australia concerning these transnational activities by perpetrators? And my last question is, when we think about digital sex crime, digital violence, or violence against children, then we need to make sure that in order to support the victims and in order to provide consistent monitoring, I understand that you have an independent organization in charge of this, dedicated to violence against children. And so could you explain what kind of an organization it is, and what do you believe is the efficacy of having this dedicated organization? And what is the recognition of this organization from the part of the people of Australia? I would like to take this opportunity to thank Dr. Brown and Dr. Harris for your very detailed presentations and sharing all of your research with us. It will be a great food for thought for Korea as well. Thank you very much.
Okay, so Dr. John Yun-jung raised a set of questions for Dr. Brown and Dr. Harris. So Dr. Brown, would you go first and answer the questions?
Thank you so much for those questions. There's a lot in there to unpack, and apologies if I miss some of it along the way. I think the starting point is a recognition that researching and investigating live streaming of child sex abuse from the perspective of live streaming platforms is an incredibly difficult task because of the nature of the technology. Most of the live streaming platforms now employ end-to-end encryption, which means that at the point when the live streaming session is taking place, it's impossible to know what's being transmitted between both ends of the live streaming session. And that means that it's very difficult to know whether what's being viewed is child sex abuse or some other form of conversation or interaction, or indeed some other form of sexual activity. So it could be, you know, adults, sexual shows, for example. And then once the live streaming session ends, there's typically no record of what's taken place, unless either end decide to record the session, and typically it wouldn't be. It's impossible to then know what's taking place. So our research hasn't focused on the live streaming platform itself. It's looked at, if you like, the periphery of the behavior. It's looked at the nature of the financial transactions that have taken place to purchase the live streaming of sex abuse, and we've taken the view that because we know those transactions have been made with facilitators of child sex abuse, therefore there's a high likelihood that those transactions were actually for live streaming of child sex abuse. Although some of that could actually have been for adult sex shows as well, and that's one of the distinctions that we can't make there. And then also we mentioned the chat logs. That was another way of us if you like, trying to understand the nature of the transactions from a negotiation perspective, and how those negotiations take place. So, and both of those sources of data, both the financial transactions and the chat logs, were received from were part of police investigations, and so this kind of replicates, in a sense, the nature of police investigations and the difficulties they have with dealing with prosecuting cases of live streaming of child sex abuse. In terms of, you mentioned regulation and the regulation in Australia. We benefit from very good regulation and a very good agency at the federal level, the E-Safety Commissioner, who has strong powers to request takedown notices of child sex abuse material when it's found on websites, on social media sites, or in cloud applications, for example. Although I'll come back to kind of the difficulties of even those regulations when we're dealing with live streamed abuse. It's very difficult for the Safety Commissioner to be able to deal with that as an issue for the reasons I've outlined. So the regulator is actually is quite powerful in its responses, and increasingly introducing new regulations. So in the coming months, there are new powers that are being introduced to assist with introducing requirements on electronic service providers on the platforms to show what measures they're taking to reduce the likelihood of their platforms holding child sex abuse material, and also they have a suite of measures around designing at safety by design. So designing out the problem of child sex abuse from the outset by working with designers, providing tools for researchers to actually design and prevent the problems from occurring in the code that they're producing in the first instance. And I think that's one of the areas that we need to look at further in terms of development into the future. I'll just touch on in terms of, you mentioned age and gender. The age profile in our study was quite bizarre in that we were seeing those, the onset and the average age in 50s. And as you say, typically users of chat platforms would be much younger. So it's either a function of the nature of the police investigation that the data came from, or it's the nature of live streaming of child sex abuse that's attracting offenders that are in mature years, essentially. And that's something that we don't really understand fully yet. It was a surprise to us when we found that was the case, and we've yet to unpack exactly what's happening there. Although it does seem to fit with a lot of the case law that we see, that when individuals are detected and prosecuted, they do often fall within that 50 to 60 age range as well. But it is a bit older than even the typical age of a physical child sex abuse offender that we'd see would be more likely to be in the 30s and 40s than they are in the 50s and 60s. Regarding gender, we just don't know. We assume that most of these individuals are male, and that's what we know from really all other studies that have investigated individuals. But what we the data that we have is quite poor around gender in those systems. In terms of regulation, I'll just touch on, you mentioned the issues around, these are often foreign companies, and how do you actually regulate with any degree of success foreign companies? And I think that is a real issue, and I think we can't lose sight of the fact that we obviously have victims, real victims and real offenders here, but we also have those platforms that are actually providing a facilitator role, and we really do need to do more to stop them from being able to act as those intermediaries between victims and offenders. And I don't think there's enough that's being done yet in that regard. I will point out that we can think of this as like a hierarchy of interventions that can be applied, and I think really in that hierarchy we're still at the early stages of thinking about how we might escalate our attention and our focus on tackling those electronic service providers. So we can think of it as kind of that hierarchy from low to high levels of pressure. Now at the low levels of pressure where I think we're at the moment, we're looking at issues like educating electronic service providers about their responsibility for dealing with CSAM on their platforms. I think about straightforward informal requests to platforms to address the material that they're putting on that are appearing on their platforms, and then more targeted confrontational approaches, where I think is where we're beginning to get to with dealing with platforms. But then we can think about a range of other measures that could be applied, that range from perhaps more naming and shaming of platforms, creating a climate that's in which control of CSAM is expected, through to providing tax incentives potentially, and sort of subsidies to encourage platforms to take action, civil action that could be taken to compel platforms to take action, and then eventually regulation. I think is like at the top of that pyramid of measures that could be taken. So I think we're some way off getting to the point where regulation is being enforced on, as you say, often foreign entities. I will just point out another way of looking at this is also from a you could see from a platform perspective the CSAM is akin to pollution in a sense, that it's an externality that's a byproduct of that service that's being provided, and it's society and those victims that are that pick up the cost. The cost isn't being picked up by the platforms themselves. So one thing to think about is whether there's a way to incentivize action to be taken by perhaps looking at the revenue streams for those companies, and looking at ways of potentially taxing perhaps the advertising revenue that goes with social media companies, as a way of costing in the true cost of their services, which at the moment the cost is distorted because they don't take into account the true cost of victims. So I think there's all sorts of innovative ways we could think about actually regulating electronic service providers in ways which could help to solve some of these issues. So thank you. That's my response to those questions.
Okay, thank you. And Dr. Harris, could you answer the questions?
Sure. Thank you so much for those questions. Please let me know if I've missed anything. I think the first question was about definitions. I think that's a really good question because we do need to be able to identify the harms that we're talking about so we can prevent, so we can respond. As I mentioned, there are challenges because we have new technologies emerging, the functions of existing technologies change, and perpetrator behaviour changes. So there's a number of different challenges there. I think what's really important is that we are engaging with, certainly with the domestic and family violence sector, but absolutely with victim survivors. They are experts in their experience. They know how this presents. They understand the individual elements and the patterns of behaviour. So I do think if we are looking at developing any, for instance, policy or legislation, it's really important that we're consulting with victim survivors here. In terms of the legislation, I think there was a question about the legislations that we have, for instance, in the Australian context. So if we're thinking about some of the behaviours I mentioned, firstly, there is legislation pertaining to domestic and family violence. We could also think about some of the stalking or surveillance legislation. I don't think that is engaged as often in my experience in working with survivors. I don't think they're engaged as often they potentially could be. We could think more about some of our cyber legislation. There is a move throughout a number of different Australian jurisdictions to bring in legislation about coercive control, and we've seen that in some other places, like, for instance, in England and Wales. I guess the potential of that legislation is that it allows us to criminalise coercive control firstly, but to think about really looking at the pattern of behaviour. Now, arguably, our domestic and family violence laws do already do that. And some of my colleagues at the Monash Gender and Family Violence Prevention Centre have done really leading work in thinking critically about the benefits, the limitations, the challenges, potentially the unintended consequences of these laws. And I won't speak to them now, but certainly one thing to think about is how it might affect or inadvertently criminalise survivors and particular groups like First Nations groups. So we might bring in some further legislation, but we do need to be really cautious and we really need to be thinking about evaluating this legislation. I think there was another question about cross-border, which Dr. Brown also spoke to. It's certainly a big challenge. I think potentially where we've had leading responses has been in regards to child sexual exploitation material. So we might be guided on, for instance, what information sharing between agencies looks like further in that space. Platforms, I absolutely agree with Dr. Brown said, have a crucial role to play here. And certainly we could argue that platforms often profit off technology facilitated violence against women and children. And we've certainly seen this with regards to, say, image-based sexual abuse. But I guess I'm a little bit encouraged by some of the changes we've seen at platforms. There's been, for instance, a few of our big platforms that have hired people who've been in the domestic and family violence sector. So there could well be some change that we see happening there. Sorry, there's a very noisy dog in my building. But there is, and I agree with Dr. Brown, there's the opportunity to put pressure on platforms to make the bad PR associated with not responding to harm is where we can maybe affect change. And that's why it could be more challenging to try and regulate smaller tech agencies. The e-safety commissioner that we have in Australia has done a lot of work around regulating different harms, especially with some of the takedown powers with things like image-based sexual abuse. So there is a lot of potential in that kind of body. There's also been really fantastic resources that the e-safety commissioner has produced for victim survivors, training for advocates. We've also got a really leading non-government agency called ResNet that has done really great training and resources, and also administered things like a phone exchange program. So there's those kind of ways that we can respond to. I think legislation has a space, platform regulation has a space, and what our government and non-government agencies can do has a space there. Absolutely, one of the problems is in regards to the design, the management, the regulation of our tech industry. I was really pleased that Dr. Ray mentioned safety by design. I'm really excited by the potential of safety by design because it is about all of those elements. It's about the technology that's being created, how it's regulated, how it's managed, and really placing the responsibility on tech companies to think about that early on. So I think all of those elements, not just legislation, is really important. For me, thinking about digital coercive control, it is essentially, it's really about understanding how domestic violence presents, the dynamics of domestic violence. And so if we're responding to these harms, I think some of the best work we can do is around training so people recognise what domestic and family violence is. Technology is just a tool. If we understand what domestic and family violence is, then I think our responses can really be enhanced. I'd also say it's really key that we look at prevention. Responses are really important, but prevention of harm is very important. So if we think about the causes and drivers of violence against women and children. I just maybe will point to some of the other challenges we have. Cross-border absolutely can be a big challenge, or cross-border transnational issues. The ways that technology can hide perpetrator identities is a big challenge. The burden of proof, if we're regulating, can be quite challenging to really establish that somebody, for instance, had a particular phone and did send those messages. That's a real challenge in just our everyday kind of domestic violence regulation. And we do see a lot of, we might refer to them as, say, abuser allies or networks engaging in harm, and it can be very difficult to regulate those kind of harms too. So there's a lot of challenge here. I think law has a role to play, safety by design has a role to play, training and education around how domestic and violence manifest, and certainly prevention are really key in this process.
Thank you. I think most of the questions have been covered and answered. So let's move on to the next discussant, Dr. 장다혜.
네. Thank you very much. Thank you for your very inspiring presentations. So we have heard about digital coercion control, especially at violence against women and children. It was very informative. My first question goes to Dr. Harris. Within your presentation, you talked about the concept of digital coercive control as well as technology-facilitated DFV. If we take a look at DFV in Korea and gender-based violence in Korea, I think your presentation has great implications on how we can respond. So I would like to connect this with the Korean situation as I ask you these questions. In Korea, according to the law, the victims of domestic violence can be separated from the perpetrators by prohibiting any forms of communications through court order so that the perpetrators cannot contact the victims using text or email or any other devices. But you also mentioned that cyber measures are not enough. And so what would be some binding measures that we can consider in addition to these cyber measures based on court orders? The second question is, those in judiciary, especially the police, I think they need to have a better understanding of digital coercive control. In Korea, if there is a reporting of domestic violence, the police would go to the site and they would be the first responders to decide whether the victim and the perpetrators would be separated. And they have this checklist, and this checklist mostly focuses on whether there is physical damage. And so there is no items on this checklist related to digital coercive control. Within your presentation, you talked about various toolkits that could be available. And so could you introduce some toolkits that could be utilized in this situation in Korea? Now I would like to go on to the presentation by Ms. Pia Pronont. So when we think about the child abusive materials, I think the situation may be quite similar in Thailand and Korea. In Korea, we have stronger responses against child sexual abuse materials, but if we take a look at self-generated materials, it's still a very big challenge for us. The police or the prosecutors, even if it is self-generated, if it can be criminalized, they are very proactively responding to these issues. So even if there is self-generated materials, it is still being punished under Korean law. Within your presentation, you talked about how you need to prosecute the adults who are leading to the generation of such materials. But if it is very difficult to find such adults, and even if there is no intervention on the part of the adults for self-generated materials, we still find it important to punish self-generated child sexual abuse materials. But NGOs are saying that it should not be criminalized, but rather it should be approached from an educational or welfare perspective. And so could you provide us with your suggestions on how the Korean police should respond to self-generated child sexual abuse material? And my second question is, within your presentation, you mostly focused on child sexual abuse materials. In the case of Korea, this actually is an issue that is very closely linked to prostitution. So, for example, a child, in order to prostitute himself or herself, would open up a website to share self-generated materials, and that could be punished as presenting or offering or soliciting prostitution. And so for when a child tries to put himself or herself up for prostitution, we do have a controversy on whether they should be viewed as victims or criminals, but the current law sees them as criminals. But in the case of Thailand, I understand that you're using the Anti-Human Traffic Act to respond to these issues. So could you share with us responses that you have in Thailand, or what is the ideal direction in dealing with child prostitution?
Thank you. So, Dr. Harris, would you answer the questions first?
Sure, thank you for those questions. So I think that the first question about the prohibiting the contact through a court order, that's certainly something that we see quite a bit in Australia. It is not uncommon, though, for the contact to continue, for there to be a breach of an intervention order because of that contact. The victim survivors that I have worked with have talked about maybe quite often the police might not recognise those breaches by technology. So I think it is really important we recognise the breaches by technology. Another way that we see, and I imagine it might be similar, is post-separation, there might be an order prohibiting contact, but there might be conditions around maintaining contact for the children. We do see perpetrators really exploit this quite a bit. So they might send a lot of abusive messages, but mention the child and then make a case to police that it is we would say a family law or a parenting matter as opposed to a family violence matter. One way that has been navigated in the Australian context is some courts are directing orders to use, say, a parenting app. There's a few different parenting apps, and that stores the contact between both parties. Now, there are benefits and limitations to that, but it is a potential way to try and navigate some of the contact. In theory, the orders should really reduce contact from the perpetrator, but in practice, I guess I'm a bit sceptical about how successful that is. The police and judiciary, certainly I think that's a big challenge in having police, say, recognise some of the technology. That there is a lot of training and a lot of work both in the police and judiciary to recognise what digital coercive control looks like. Perhaps a few years ago, there was a tendency to sometimes say, that's not domestic violence. That might be annoying that you're receiving, for instance, that abusive contact, but it's not domestic violence. So I think it's really important that we do have that education for police and judiciary around what domestic violence looks like and how technology is involved and part of that. And that means recognising firstly how technology is used to enact other forms of abuse, but also how there might be unique features. So it is really useful, I would say, to try and educate around how technology can present in those different forms. And sometimes if we have risk assessments, there's ways, for instance, there's ways that we might incorporate technology further. So there might be a element of a risk assessment or a step in the police investigation to think about stalking. And so I think it's really important that we say, well, how might technology be used in stalking? Or if we're thinking about, say, emotional abuse, well, how might technology be used in emotional abuse? So it's sometimes reflecting on the policy, practice, risk assessment that we have. In terms of the toolkits that we might have, there's a number of different checklists that advocates will use, for instance, around the forms of technology, accounts that might be shared, and that can be really useful because our lives are tied together with our partners in so many ways that we might overlook some of the vulnerabilities and channels that they might attack or might engage us through. So I think it is really useful to try and develop a checklist of, so for instance, it might involve for us, we have different travel cards, and it involves thinking about everything like those travel cards, because if somebody has access to your travel account, they can see where you've moved from. So it's important that we're really trying to think about all of those points of attack, I guess. I think a definition is important, but to really develop a toolkit here, what we need to be doing is asking somebody about what their partner or what the perpetrator is doing that makes them feel uncomfortable, uneasy, that makes them feel more restrained. And that means that we need to look at their overall account of domestic and family violence. I sometimes think if we ask people directly, we might miss steps, or if we're just off a checklist, we might miss steps. But if we're really asking them about their experience and we're really trying to unpack the impact on their lives, then we will start to see those kind of behaviours. People will talk about the ways they've been confined and restrained. So it's really about, I think, making the effort to engage with survivors and not just being governed by behaviours that might be in legislation, that might be in risk assessments, but thinking about what we might miss. And that's so important because perpetrators will use individualised strategies with so many strategies. And so if we're not really thinking more inclusively about somebody's experience, there's just too much danger that we will miss the impacts and the risk that they're facing.
Okay, thank you. Then Lieutenant Colonel Piatpom, would you please respond to the questions?
Yes, let me start by saying that self-journalist child sexual abuse material here in Thailand, even though the children are younger than 18 years old commit the crime, it can criminalize according to our law, but according to the criminal responsibility for the child below 7 years of age who commit a criminal offense, he or she is not liable to punishment. This means that criminal responsibility begin when the child is older than 7 years. In case the child who is older than 7 years but not more than 40 years, if they share or produce their own sexual material, they commit a criminal offense. But normally the court consider the judge will consider the child sense of responsibility and other attributes before deciding whether he or she deserves a punishment. So I think this is a difficult issue, and that's why I raised this issue to maybe to gain your attention, because here in Thailand, when it comes to young children, especially less than 18 years, it's quite difficult for us to place charge on them because they're so young, and I try to use Child Protection Act to, I don't believe in punishment because it has nothing to do with it can't help the children in the development. So normally I going to use a Child Protection Act with using a multidisciplinary team to taking care of these children, because I think they need protection in somewhere. And this is a difficult question, so I have no good solution when about this situation. And we also have anti-human trafficking as well, and it's the same answer that I normally never place charge on this cause because it's too severe for children. And I hope that this conference will help to think about how to respond to the child who produce self-generate sexual material. So I'm sorry that I could not provide the good answer in this conference, but I hope that I'm going to in the near future, I'm going to find a better way. I mean, in Thailand, maybe we have another solution for protecting children to from committing this crime. So that's my answer.
Okay, thank you. So the last discussant is Prosecutor 이진희. 이진희 검사님 토론 해주시기.
Your discussion, please.
Yes, thank you, Ms. Yu. And I'm Prosecutor Lee Jin-hee in the International Criminal Affairs Division, Ministry of Justice. And currently, I'm taking charge of mutual legal assistance matters between Korea and foreign counterparts in Ministry of Justice. Thank you for inviting me to this meaningful conference, and it is my honor to participate in discussion too. Thank you all for your detailed and keen presentations today. And I would like to have a discussion on the presentations of Mr. Gang and Ms. Mecchiano first. And I'm going to ask some questions to Mr. Gang in Korean first. 안녕하십니까? 네.
Hello, Dr. Kang. I have a couple of questions for you. Within the metaverse, as for defamation and sexual harassment through chats, the data will remain in the server, but other than the victim's statements, how can the investigation authorities collect evidence for sexual assault and stalking in metaverse? And second question, it is highly likely that the offenders, victims, and operators of metaverse will have different nationalities. And even if the children fall victim, it will take a long time to solve it because you have to go through multiple MLAs, or it could be impossible to extradite and punish the offenders when there are no punishment provisions in the counterpart country's laws. So I completely agree that preventive measures are as important or more important than punishment. But is it possible for us to request such preventive actions to foreign businesses and operators in Korea?
I'd like to ask some questions to Ms. Mecchiano. Thank you, Ms. Mecchiano, for your presentation again. First of all, your preventive efforts using chatbot are significantly impressive. While offenders use the developed communication technology, and it is easier to victimize the young people and females, especially digital sexual crime and sexual exploitation. But investigation authorities could also use communication technology as well to collect evidence and trace suspects and criminal processes by using the advanced technology too. In line with use technology, I totally agree with implementation of chatbot system in Thailand. On this point, I would like to ask for sharing your perspective whether the chatbot is operating through the separate application or it is based on other platform. In addition, since conversations with chatbot probably includes massive personal information, I would be grateful if you explained how you could manage this sensitive data. Second, your statistics show that most of the cases take place in social media and games of foreign businesses. In this sense, do you send more mutual legal assistance requests than before to foreign counterparts for investigation? It would be appreciated if you tell us your major difficulties or challenges while dealing with these cases. Thank you.
Okay, prosecutor posed the questions for Dr. Kang and Lieutenant Colonel. I think it'd be better if Lieutenant Colonel goes first and answer the questions. Would you please?
Yes. For your first question about the safety and how we handle of the data, sensitive data. So from the beginning of my project, confidentiality and safety principles are the paramount of the project. So many steps have been taken, ranging from data protection measures as well as establish ethical standards to raise awareness for our stakeholders who getting involved in this project. So it means that all agencies involved in this project must practice in compliance with law and regulation, and in order to secure personal information, and also include, we also provide training for other government agencies to collect and store data in an ethical and safe manner. So the measure also include the establishment of the protocol between government and non-government agencies to grant the permission for only specifically trained persons to access and handle all the sensitive data that we collect from the chatbot. Yeah. And your second question about MLab. This is the difficult part for us because there are a lot of challenge when it comes to cross-border, especially bureaucratic red tape in our organization. For example, my last request, it takes like 6 months or more to receive all the data back from another country. So it means that while the perpetrator go one step ahead, they commit crime without treaty and procedure, but we are still very busy making with a ton of document to submit to request. So normally I personally use my personal connection, and somehow I use an informal mechanism like Interpol channel, or even I have to establish a good relationship with police liaison in different countries in Thailand. So this is much more faster, because when it comes to digital evidence, we cannot wait because it can alter, it can be deleted. So I think, but I don't for myself, I didn't encourage anyone to do it like this because it seemed like if I die today, my connection will disappear and everything will have to start over again and again. So I don't agree to use the personal connection, but at the moment we have no choice. So we just, I just hoping that in the future we will have an informal mechanism that make us receive and sharing data between the country more faster. Yes, that's all my answer.
Thank you. And Dr. Gang, would you answer the questions?
Prosecutor Lee asked a very keen question that is very meaningful from the practical perspective. Well, I am not in practice, but let me share with you my thoughts. If we have sexual harassment and stalking in the real world, I believe that recordings by the victims is essential evidence for investigation, and testimonies and CCTV records are also very important. Within the metaverse, if there is stalking or sexual harassment against avatars, not only do we have recordings by victims, but we also have records of activities by avatars that can be used, such like CCTV records. And there are also other avatars in that space, and they can become someone who provides testimonies. And I understand that avatar activity records are possible. For example, in metaverse shopping malls, they have information on how long an avatar has resided in a certain space, what kind of movements that there were, and what they were glancing at. Of course, all of these records are not available for all metaverse platforms, but as I have mentioned before, in order to prevent acts of abuse or exploitations in the metaverse, many of the platform developers are actually applying such recording technologies with the consent of the users. Concerning the second question, this is a question that I have given a lot of thought to. If we have foreign companies that has a metaverse service in Korea, how do we deal with this? This actually depends on whether we see metaverse as games or an online platform. If we view metaverse as a game, then we can apply the Game Industry Promotion Act or the Youth Protection Act, but many legal experts believe that rather than metaverse being a game, we need to view them as online platforms. And if we view metaverses as platforms, then that would actually be supervised by the Fair Trade Commission, because last January, they came up with an act to regulate the fair intermediary service of online platforms. We could also refer to the December 2020 European Commission's Digital Service Act that was applied to intermediary services online to enhance transparency of online platforms, as well as the Digital Market Act by the European Commission that includes requirements and responsibilities of platform businesses. So the proposal has been made by the European Commission in January of 2020. So we can actually take this into consideration. And I believe that we can find the grounds to ask the platform companies to have preventive measures designed into their structure.
Now, all the questions have been answered and covered, and it'd be nice to have more discussions, but unfortunately, time is up. So I want to thank very gratefully our four speakers and discussants here for great presentations and discussion. And I believe that we had a valuable conversation on the current trends and practices related to technology-assisted crimes. And we hope that today's conference will serve as an opportunity to continue discussion on the protection of women and children's human rights. So this brings us to the end of the conference, and I would like to once again thank today's speakers and all participants. We look forward to seeing you again next year. Thank you.